Well, let me make just a brief comment about, and you really raised the Senator Fairfield a comment that I was going to make, because I've gotten emails, and a bunch of them, the last couple of weeks, probably 500, 600, I don't know, I never counted them, but I've tried to respond. I was good until 11:30 last night, and then I quit. And with the staff being closed, building being closed last week, it was just tough to get all of them done. We got them done. But what you said about this, I've had people email, please don't take my guns away from me. They really, some people really believe this is a debate taking place in this Senate, that we're about on the verge of voting to take their guns away from them, period. I don't know where that's coming from, but be that as it is, let me just say this. One senator mentioned that criminals going to do what criminals going to do, and that's exactly right. You pass open carry, criminals will openly carry a weapon. Doesn't matter. They're going to do that. Criminals going to do what criminals going to do. We don't have an open carry policy for anyone that is not law enforcement in South Carolina now. That's the reason I supported our CWP law back in '96 when we passed it. For the first time in over 100 years, someone who was not a commissioned law enforcement officer, didn't have a constable's commission. I remember getting those calls from people wanting a constable's commission. For the first time in over 100 years, somebody could get the right. Self-defense has been talked about in a variety of ways, in a variety of places, concealed. If a person walks down the street in an open carry situation, and I haven't done any great research on it, but I know what the law is. And the law is, unless an officer has probable cause to believe that that person, or he knows that person, is in fact a felon or a stalker or whatever else that person has done, he's got no call to ask him anything. If the law provides him the right to South Carolinians to openly carry without a permit, he can't ask them nothing until he gives evidence of committing a crime. That's what we would be invoking with a policy that permits open carry, period. Now, this idea about permission, let me tell you the way I view permission. The way I view permission is the idea that when we and we debated this when we passed the CWP law. Permission would be, well, you got to get SLED to clear you. You got to get SLED. SLED's going to have to determine, is your background clean enough for you to get a CWP or to do whatever. Well, we didn't do that. South Carolina is a shall issue state, which means simply this. You meet the requirements of the statute. Be a law-abiding, we talked about a law-abiding citizen. That's what the statute pretty much says. Clean criminal history and the minimal training. It's not all that expensive, overly burdensome. Most people pay that for one of these, pay what they would pay for a CWP to get a disposable cell phone, certainly a month or two internet service. That's what we're talking about, to get a CWP. And how many people do you know walking around today that does without either one or the other? I don't. So I think it's a de minimis cost. They don't ask permission in the sense that they've got to get SLED's approval to clear them. They meet the requirements of the statute. The law says SLED shall issue that permit. That's the way we wrote it. And again, I would just, as far as the infringement issue, Justice Scalia, I thought, said it pretty well. And he wrote the majority in the Heller decision. Prior to Heller, there really wasn't, and I've really read up on this. I haven't done the research in other states, but I've read about the Seventh Circuit case. I've read about the Ninth Circuit case. The Ninth Circuit out in California, the case out there, based on Heller. And these cases are coming about based on Heller, as the lawyers in here know. And based on Heller, and I've had some folks in support of this bill say, well, look at these cases. And California was not a shall issue state. And that was one of the problems the Ninth Circuit had out there. Up in Illinois, the case out of the Seventh Circuit, based on Heller, and again, prior to Heller, you know, the whole issue of the Second Amendment rights was more of a collective right than an individual right. And the lawyers in here that have read those cases know that. Heller strengthened the Second Amendment substantially with that recognition, and Justice Scalia wrote that opinion. That fellow in the black robe that people have criticized strengthened the Second Amendment right as it existed, as opposed to what had happened previously over the 200 years of history of the Supreme Court decisions on the Second Amendment. But up in Illinois, Illinois didn't even issue a CWP. They had no CWP law. And after Heller, and you couldn't carry a gun, sort of like we were pre-96 before we passed the CWP. And the Seventh Circuit ruled that, look, you got to have a CWP law, or you got to have, you violate the Heller opinion does give you the right to self-defense, as the senator from Spartanburg has argued repeatedly, but by the same token, the state, and according to Justice Scalia, let me just read what he said, arguably the most conservative justice to have served on the Supreme Court. He reads the Constitution. If anybody hadn't read the Heller case, it's 157 pages long. This is on page 57 of it, and it is a really great history lesson in the Second Amendment. This is what Justice Scalia said. Like most rights, the Second Amendment is not unlimited. And we've heard the arguments, oh, you can't infringe. There is no limit. I do whatever I want to, whatever. It is not a right to keep and carry any weapon whatsoever, in any manner whatsoever, and whatsoever purpose. No. And it goes on, and I'm not going to read, but the point is, both the courts and our public policy, I believe, conforms to Heller. I don't believe we have an unconstitutional Second Amendment issue in South Carolina as it relates to citizens' citizens being able to reasonably get a permit. They don't have to beg permission. They meet the requirements of the statute. It's not black or white, or red or yellow, or anything like that, or based on who you know. They don't have to come to us to get some public official to sign off on it. They apply, and if they meet the requirements of the statute, SLED shall issue. That's what the law says.
That's tougher than a notary.
Yeah, that's better than a notary. That's right. A notary, we got to sign off on it. If you don't sign off on your local notaries, they don't get them. So it's better than that. So we recognize, I think we honor the Second Amendment in South Carolina. I think we do a better job honoring it today than we did prior to the CWP law, certainly based on what Heller, Justice Scalia wrote for the Supreme Court in Heller. And that's all I have.